You are 72 years old. You have lived in your home for 31 years. You paid off the mortgage. You raised your children there. Every corner of that house holds a memory. Then one morning, you suffer a stroke. You survive, but you cannot speak. You cannot sign your name. You cannot make decisions. Your daughter rushes to the bank to pay your property taxes before the deadline. She walks in. She gives them your name. And the bank tells her they are sorry, but she has no legal authority over the account. She cannot pay your bills. She cannot access your accounts. She cannot sell, refinance, or even maintain your home. Everything is frozen and the bills keep coming. This is not a rare scenario. According to the Consumer Financial Protection Bureau, this happens to families every single day across America because 5 simple documents were never filed. And today, I am going to walk you through those 5 documents, every single one of them, so this never happens to you or anyone you love. Every fact I am about to share comes directly from official government sources, including the Consumer Financial Protection Bureau, Medicare.gov, the IRS, the Social Security Administration, and verified research from major policy organizations. Now, here is why you need to stay until the very end. There is a hidden tax trap that I will explain when we get to the 5th document that can cost your children hundreds of thousands of dollars in capital gains taxes. And it all depends on one single decision you make about your home while you are still alive. Most people have no idea this trap exists, but by the end of this video, you will. Let me tell you about a man we will call Robert. Robert was 67 years old. He was a retired electrician living in Ohio. He owned his home free and clear with no mortgage. He had a modest pension, his Social Security check, and a small savings account. Robert considered himself a responsible man. He had told his 2 adult children, David and Karen, exactly what he wanted. The house would go to Karen because she lived nearby. David would get the savings account. Simple and fair. He told them this over Thanksgiving dinner. Everyone nodded. Everyone agreed. But Robert never wrote it down. He never signed a will. He never filed a power of attorney. He never set up a transfer on death deed. He figured the kids know what he wants, and that is enough. Then Robert had a serious fall. He hit his head. He developed a brain bleed that left him unable to make decisions. Karen went to his bank to pay his property taxes. She was turned away. She called Social Security to manage his benefits. They told her she had no authority. She tried to arrange home repairs so Robert could eventually come home from rehab, but she could not sign contracts on his behalf. David, meanwhile, hired a lawyer and petitioned the court for guardianship. And suddenly Karen and David were no longer on the same page. The court got involved. Legal fees started piling up. Robert's home sat vacant for 11 months. Property taxes went unpaid. A lien was placed on the house. 11 months with no authority and no plan, and the home was nearly lost. Every single piece of this could have been prevented if Robert had filed 5 documents. The first and single most important legal document for any homeowner over 60 is a durable financial power of attorney. This document gives someone you trust, and this person is called your agent, the legal authority to make financial decisions on your behalf if you become incapacitated. That includes paying your mortgage or property taxes, managing your bank accounts, handling insurance, and even selling your home if needed. Now pay close attention to the word durable. According to the Consumer Financial Protection Bureau, a regular power of attorney actually stops working the moment you become incapacitated. That is the exact moment you need it most. A durable power of attorney specifically remains in effect even after you lose the ability to make decisions. The CFPB is very clear on their website that this document is called durable because it remains in effect even if you become incapacitated, and that you retain the ability to change it or cancel it at any time while you still have capacity. Here is the trap most people fall into. Many seniors believe that their spouse or their adult child can automatically step in and handle their finances if something happens. The Consumer Financial Protection Bureau is explicit on this point. That is false. Without a valid, durable power of attorney, no family member has legal authority to act on your behalf. Not your wife, not your husband, not your son, not your daughter. And without it, your family has only one option, which is petitioning a court for guardianship or conservatorship. This process is lengthy, expensive, and very public. It can lead to family conflict, competing petitions, and ultimately, the court, not your family, deciding who controls your life and your finances. There is one more important thing related to this. The Social Security Administration offers something called Advance Designation of Representative Payee. This allows you to name up to 3 individuals who could manage your Social Security benefits if you ever become unable to do so yourself. You can set this up right now through your My Social Security account online at ssa.gov. It is free, it takes just a few minutes, and it can prevent an absolute nightmare for your family. The second document you need is a last will and testament with specific provisions for your home. And I do not just mean any generic will, I mean one that specifically addresses what happens to your home. According to the Consumer Financial Protection Bureau's official guide for older Americans, a will is the legal document that sets forth your wishes for what happens to your property when you die, and that specifically includes your home. Here is the misconception that so many seniors have. They believe that telling their family what they want is enough. It is not. It is not even close to enough. Without a valid written will, your home passes according to your state's intestacy laws. That means the state, not you, decides who inherits your house, and the state's formula may send your home to people you never intended. Without a will, the process goes through probate, which can take over a year. Research indicates that probate costs can consume 3 to 7% or more of the total estate value. On a home worth $500,000, your heirs could lose $15,000 to $35,000 or more just in probate expenses. This process can also create what are called tangled titles, which means the person living in the home is not listed as the legal owner. They cannot sell it, they cannot refinance it, they cannot insure it properly. In some cases, they cannot even make basic repairs because they have no legal standing. If you are over 60 and you own your home, you need a will. And if you already have one, pull it out and check the date. If you wrote it before a major life event like a divorce, a death in the family, or the birth of a grandchild, it may need to be updated. Free legal help is available for people over 60 through the Elder Care Locator at 1-800-677-1116. This is a free government-funded service that will connect you with legal assistance in your area. The third document is one that most seniors have never even heard of, and it might be the most powerful one on this entire list. It is called a Transfer on Death Deed, also known as a TOD deed. This is a legal document that simply says, when you die, your home passes directly to the person you name. No probate, no court, no waiting. According to the Consumer Financial Protection Bureau, it is simpler and less expensive to set up than a trust. As of 2026, approximately 32 states plus the District of Columbia allow transfer on death deeds. You file it with your local recorder of deeds, and you keep full control of your home for as long as you live. You can change it or cancel it at any time. Now, if your state does not allow a TOD deed, the alternative is a Revocable Living Trust. According to consumerfinance.gov, a living trust lets you transfer your home to a trust that you control during your lifetime. You are your own trustee. When you pass away or become incapacitated, a successor trustee you have already named steps in and manages the property, again, without going through probate. But here is the critical trap with trusts. Many people create a living trust and think they are done. They are not. The Consumer Financial Protection Bureau is very specific about this. A living trust is ineffective until property is actually transferred into it. That means you must retitle your home in the name of the trust. If you skip this step, your home still goes through probate even though you paid a lawyer to set up the trust. It is one of the most common and costly mistakes in estate planning. And the CFPB also warns that trusts are sometimes marketed by unscrupulous individuals and firms. If anyone approaches you offering to set up a trust, check their references carefully and speak with an independent attorney first. There is one more critical consideration here that involves Medicaid. According to Medicaid.gov, state Medicaid programs are required by federal law to seek recovery of payments from the estates of individuals aged 55 or older for nursing facility services and home and community-based services. States can even place liens on your home during your lifetime if you are permanently institutionalized. However, and this is very important, states may not recover from your estate if you are survived by a spouse, a child under 21, or a blind or disabled child of any age. Understanding these Medicaid estate recovery rules before you make any transfer decisions about your home is absolutely essential. The fourth document protects your body, not just your bank account. It is called an Advance Healthcare Directive, and according to Medicare.gov, it has two parts. The first part is a healthcare proxy, sometimes called a durable power of attorney for healthcare. This names someone you trust to make medical decisions on your behalf if you cannot speak for yourself. The second part is a living will. This describes which treatments you want or do not want if your life is threatened. We are talking about things like dialysis, breathing machines, resuscitation, and tube feeding. It also records whether you want to donate your organs or tissues. Now here is the trap. Many seniors believe that their financial power of attorney covers medical decisions too. It absolutely does not. The Consumer Financial Protection Bureau makes this very clear. A financial power of attorney and a healthcare directive are two completely separate documents. You need both. And here is another mistake people make. They create the directive, but they put it in a filing cabinet and never tell anyone where it is. If no one knows where your directive is during an emergency, it might as well not exist. You need to give copies to your doctor, your hospital, your healthcare proxy, and your family members. And here is some genuinely good news. Medicare covers advanced care planning discussions at no cost to you when it is part of your annual wellness visit. So the next time you see your doctor for that yearly checkup, bring this up. Ask them to help you put your wishes on paper. You have the legal right to do so. Medicare.gov specifically states you have the right to make your own healthcare decisions and carry out your plans as you choose. The absence of a healthcare directive is one of the primary reasons families end up in conservatorship proceedings. Do not put your family through that. And now we come to the fifth document. And this is the one that saves you money every single year and contains the hidden tax trap I promised to tell you about. This document is your Homestead Exemption or Senior Property Tax Exemption application. Most states and many cities offer homestead exemptions or senior property tax exemptions. These programs reduce the taxable value of your home, which lowers your property tax bill every year. Some states also offer tax freeze programs that cap how much your taxes can increase year to year. But here is what catches people off guard. These exemptions are not automatic. You must file an application with your local county assessor or tax office, and in many places, you have to renew it every year or every few years. Anybody can forget to fill out the renewal notice, especially older adults who get a lot of mail. If you miss the deadline, you pay full price. And over 10 or 20 years of retirement, that can add up to tens of thousands of dollars you simply threw away because you did not file a piece of paper. On the federal tax side, the IRS now offers Form 1040-SR, which is a senior-friendly tax return with larger print designed specifically for taxpayers 65 and older. And there is an important new development. For tax years 2025 through 2028, there is an enhanced deduction for seniors. If you are 65 or older, you may be eligible to claim an additional $6,000 deduction, or $12,000 if both you and your spouse are 65 or older. This is in addition to the existing standard deduction and the additional standard deduction that was already available to seniors. This can meaningfully reduce your tax bill every single year. Now, if you are thinking about selling your home, remember the IRS allows you to exclude up to $250,000 in capital gains from the sale of your primary residence. That is $500,000 for married couples filing jointly. The home just needs to have been your primary residence for at least 2 of the last 5 years. That comes directly from IRS Publication 523. And now here is the hidden tax trap I warned you about at the very beginning, and this is the one that can cost your family the most money. If you deed your home to your child as a gift while you are alive, your child inherits your original cost basis. Let me put that in real numbers so you can see exactly how devastating this can be. Say you bought your home for $50,000 40 years ago. Today, it is worth $400,000. If you gift that home to your son while you are alive, his cost basis is $50,000, which is what you originally paid. When he sells that home, he owes capital gains tax on $350,000 of profit. At the current long-term capital gains rate, that could easily be $50,000 to $70,000 or more in taxes. But if you keep the home in your name and your son inherits it after your death, something completely different happens. Under IRC Section 1014, the cost basis steps up to the fair market value on the date of your death. So his basis becomes $400,000. And if he sells it for $400,000, he owes $0 in capital gains taxes. $0. That one decision, gift versus inheritance, could be the difference between your child keeping their financial security or losing a massive portion of it to taxes that were completely avoidable. This information comes directly from IRS Publication 551 and the IRS Gifts and Inheritances FAQ page. Please talk to a qualified tax professional before you transfer your home to anyone. You now know all 5 documents, but knowledge without action changes nothing. So here are 3 concrete steps I want you to take this week. Not next month, not someday, this week. The first step is to gather and file your 5 documents. Sit down at your kitchen table with a pen and a notepad. Go through this list. Check off which documents you already have. Circle the ones you are missing. You need a durable financial power of attorney, a last will and testament with specific instructions for your home, a transfer on death deed or a revocable living trust, an Advance Healthcare Directive that includes both a living will and a healthcare proxy, and your homestead or senior property tax exemption application. If you are missing even one of these, you have a gap. And gaps cost families their homes, their savings, and their peace of mind. For the documents you need help creating, call the Elder Care Locator at 1-800-677-1116. This is a free government-funded service for people over 60. They will connect you with free legal help in your area. The second step is to share your documents with the right people. Filing a document and putting it in a drawer is not enough. Your durable power of attorney needs to be on file with your bank and your financial institutions before an emergency happens. The Consumer Financial Protection Bureau warns that banks may reject a power of attorney they have never reviewed before. Do not wait until a crisis to find this out. Your Advance Healthcare Directive needs to be in the hands of your doctor, your hospital, your healthcare proxy, and at least one other trusted family member. And while you are at it, log into your My Social Security account at ssa.gov and set up your advanced designation of representative payee. Name up to 3 people you trust. It is free. It takes just a few minutes, and it can prevent a nightmare. The third step is to review and update everything once a year. Life changes. People change. Laws change. The person you named as your agent 5 years ago may no longer be the right choice today. The will you wrote before your divorce may send your home to someone you never intended. Set a date once a year, maybe your birthday, maybe the first day of the new year, and review all 5 documents. Make sure they still reflect your wishes. Make sure the right people still have copies. Make sure your property tax exemption has been renewed. What I have shared with you today could change the outcome of your retirement. It could protect your home. It could save your family from court battles, tax penalties, and financial heartbreak. But here is the reality. The government does not send you a reminder to file these documents. There is no alert that pops up on your phone when a new rule changes, and the algorithm decides what you see, not you. So share this information with someone you love who owns their home and is over 60, because the 5 documents we talked about today do not help you after the crisis hits. They only work if you file them before it is too late. For more information like this, stay connected with Social Security Vault.